Good day, everyone. I am Elma Tusoy, and today I will be the one to report about my topic, which is Chapter 8 Assignment of Credits and Other Incorporeal Rights, Article 1631 to 1636 under the Law on Sales. So, Article 1631, one who sells for a lump sum the whole of certain rights, rents, or products shall comply by answering for the legitimacy of the whole in general, but he shall not be obliged to warrant each of the various parts of which it may be composed, except in the case of eviction from the whole or the part of greater value. So Article 1631 talks about a situation where a person sells a group of rights, rents, or products all together for one fixed price or lump sum. So the law says that the seller only guarantees that the whole thing being sold is legitimate or valid. The seller does not guarantee each small part of what is included. Exception: if the buyer later loses the whole thing or the most valuable part because it was not really owned by the seller, this is called eviction. Then the seller becomes responsible. In short, the seller promises that the entire package is legal, but not that every single part inside is perfect, unless the buyer is deprived of the whole of or the most important part. So comment, sale for the lump sum of the whole of certain rights, rent, or products. The warranty is on the legitimacy of the whole. So example 1. The sale of business income rights. Han owns a small apartment building. She sells all her rights to collect rental income for the next 5 years to Giselle for 500,000, which is lump sum. So later on, Giselle discovers that one tenant stopped paying rent because the tenant moved out. So Giselle cannot complain to Han about that one tenant. Why? Because Han only guaranteed that the right to collect rent existed, not that each tenant would always pay. So example 2, eviction. Seller becomes liable. But later, a court rules that half of the building was never legally owned by Han, and Giselle loses the right to collect rent from the most valuable part of the property. So now, Han is liable. So why? Because Giselle was evicted from a major part of what he bought, and Article 1631 says the seller is responsible in this case. So Article 1632, should the vendor have profited by sum of fruits or receive anything from the inheritance sold, he shall pay the vendee thereof if the contrary has not been stipulated. So Article 1632 says that kung ang seller naka-profit pa after selling the inheritance, kinahanglan niya ihatag ang profit sa buyer unless na sila agreement. So comment, rule if vendor still profits despite sale of the inheritance. Since the vendor has already sold the inheritance, he should not profit except of course insofar as the price is concerned. Hence the obligation to pay as a rule. So example, rental income from inherited property. So Mai inherited a small apartment from her parents. She sold all her inheritance rights to Rodel for 800,000 pesos. After the sale, the tenants paid 30,000 pesos rent for the month. Mai received the rent even though she already sold the inheritance. What does the law say? So Mai must give the 30,000 pesos to Rodel. Why? Because the rent is the fruit or income of the inheritance, and Article 1632 says the seller cannot keep it after selling. Article 1633, the vendor shall on his part reimburse the vendor for all that latter may have paid for the debts and charges on the estate, and satisfy the credits he may have against the same unless there is an agreement to the contrary. So comment, corresponding duty of a buyer. The article is clearly just and fair. Example, Juan sold his house and lot to Maria. Before selling, Juan paid 60,000 in unpaid real property taxes. Juan also paid 40,000 in homeowner association dues. After the sale, Maria now owns the house and lot. Under Article 1633, Maria must reimburse Juan 100,000 pesos because Juan paid the debts charges for the property, unless Juan and Maria agreed in their contract that Juan would shoulder those expenses. Maria must pay him back. Article 1634. When a credit or other incorporeal rights in litigation is sold, the debtor shall have a right to extinguish it by reimbursing the assignee for the price the latter paid therefor, the judicial cost incurred by him, and the interest on the price from the day on which the same was paid. A credit or the incorporeal right shall be considered in litigation from the time the complaint concerning the same is answered. The debtor may exercise his rights within 30 days from the date the assignee demands payment from him. So Article 1634 means that kung ang credit or utang na naa sa korte o gibaligya sa lain nga tao, ang debtor has the right nga itapuson or extinguish ang utang pinaaging sa bayad sa assignee sa price nga iyang gibayad. Apil ang judicial cost og interest. A credit is considered in litigation once the complaint is answered, og ang debtor must exercise this right within 30 days from the time nga ang assignee mangayo og bayad. Comment. Sale of a credit or other incorporeal rights in litigation. A. Example. A sues B to recover a credit of 1 million. When the complaint is answered by B, the credit may now be said to be in litigation. If A sells the credit to a third party X for say 200,000, A may have done this to avoid the delay in collection. B may redeem the credit from X by paying X the sum of 200,000 within 30 days from the time X demands payment of the 1 million. So B, reason for the law, equity. Besides, this will prevent speculation of the part of the assignee. Thus, in the example given, X bought the credit only the expectation that he would eventually collect the entire credit of 100,000. If after all, A was willing to receive only 20,000, the debtor may just as well receive the benefit. So see, this is another example of legal redemption. This is applicable only in the case of sale. Hence, the article does not apply to a barter or the donation. So E, two questions must be answered affirmatively because this article can be applied. 1. Was there a sale? 2. Was there a litigation or suit pending at the time or moment of assignment? This article applies only to a claim in litigation, the meaning of which is not claim upon to litigation but one which is actually litigated, that is to say, disputed or contested, which happens only after an answer is interposed in a suit. So Robinson versus Gary, 8 Philippine 275. So G, regarding paragraph 3, the demand here is either judicial or extrajudicial. So Article 1635, from the provision of the preceding article shall be accepted the assignments or sale made. So 1. To a co-heir or co-owner of the right assigned. 2. To a creditor in payment of his credit. 3. To the possessor of a tenement or piece of land which is subject to the right in litigation assigned. Comment. And instances when the legal redemption is denied. A. Reason for paragraph 1. The law does not favor co-ownership. B. Reason for paragraph 2. The presumption here that the assignment is above suspicion. The assignment here in the form of dasyon pago is thus perfectly legal. So C, example of paragraph 3. 1. A mortgage his land to B, but A sold it to C. Later, while suit is pending, C acquires mortgage credit assigned to him by B. A has no right to redeem the mortgage credit. This is because C's purpose is presumably to preserve the tenement. 2. A or B. For non-payment, B. Attach the property. Property was sold to C, who also acquires the credit. A. Cannot redeem. C. Purpose is to preserve the tenement. There is evidently no speculation here. So chapter 9, general provision. Article 1636. In the preceding articles in this title governing the sale of goods, unless the context of or subject matter otherwise requires. 1. Document of titles to goods includes any bill of lading, the warrant, quittance, or warehouse receipt or order for the delivery of goods or any other documents used in the ordinary course of business in the sale or transfer of goods as proof of possession or control of the goods, or authorizing or purporting to authorize the possessor of the document to transfer or receive, either by endorsement or by delivery, goods represented by such documents. Goods includes all chattels personal but not things in the action or money of legal tender in the Philippines. The term includes growing fruits or crops. So order relating to documents of title means an order by endorsement of the documents. So quality of goods includes their state or condition. Specific goods means goods identified and agreed upon at the time or a contract a sale is made. An antecedent or pre-existing claim, whether for money or not, constitutes value where goods or documents of title are taken, either in satisfaction thereof or as security thereof. 2. 2. A person is insolvent within the meaning of this title, who either has ceased to pay his debts in the ordinary course of business or cannot pay his debts as they become due, whether insolvency proceedings have been commenced or not. So goods are in a deliverable state within the meaning of this title when they are in such state that our buyer would, under the contract, be bound to take delivery of them. So comment, definition of certain terms. The article defines certain terms in connection with the sale of goods. Note that real properties are not involved here. So that's all. Thank you.